The court said, petitioner's attorney, please draft the findings of fact, conclusions of law, and judgment of divorce for me, have it to me within 30 days under the 5-day rule. What that's saying is that they basically have to, there's a marital settlement agreement, which is the agreement that you and the other party has relative to custody, placement, support. This means that you went to a default divorce hearing. You weren't contesting anything, you're on the stand, and you're basically saying, yes, 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 I agree, I agree, I agree, I agree. And the court says, yes, thank you very much for making my job easy, and now I'm going to continue making my job easy, and I'm going to have one of the attorneys draft the order, basically writing down what I said, even though they actually didn't say all of it, but we all just throw it all in there, and then they sign it. And they sign it under the 5-day rule, meaning the attorney sends it. If they don't have an objection within 5 days, they sign it. But it should say the judgment of divorce is granted and the order is entered as of the date of the hearing.
What happens if I may, on this, what happens if the draft is not good and you don't like it and after 5 days?
Now, so some attorneys will say, they probably don't do it very often when there's a pro se person on the other side. But if it's an attorney on the other side, what they'll do is they'll send it to the other attorney, their draft of the findings, and the other attorney is going to sign approving as to form. But approving as to form. And so what you're saying is that, yes, this is consistent with what the court ordered. You're not saying, I agree with everything that was ordered, you're just approving as to form. If your attorney or you as a pro se person objects to the order, so they send it to the court and you object, under the 5-day rule, you would file your notice of objection and read your local rules. If you go online, Wisconsin Circuit Court access, there's all the local rules. Read the rules, because in some counties, when you do an objection, you have to put forth your proposed findings of fact, conclusions of law, and judgment. And then the court chooses either which one to sign, or if they're thoroughly confused, they'll have a hearing to determine what's the difference between these two and why I should be signing one over the other.
Would it be pertinent then in that case, let's say it gets to that point, would it be pertinent in that case, in my situation, the attorney has given a PMSA twice over to me, and basically it was a draft of everything that was how he wanted it for her. When we agreed, we sat down, we talked about it, we came to an agreement, we shook hands, and then it was more of the same. And so after that fact, would it be prudent for me to come up with my own PMSA ahead of time, even before trial, to enter it to the judge and say, I've been through this a number of times before?
This is actually a different issue.
Okay.
A findings of fact, conclusions of law, and judgment of divorce is the order that the court ruled. Right. A PMSA is a partial marital settlement agreement. And so I'm assuming you had a partial marital settlement agreement on custody and placement?
Yes. Okay,
so partial marital settlement agreement on custody and placement. So you went to mediation, you came to the terms, and now it's a dispute as to what the agreement is. Two issues here. One is that until the court signs, and depending on the county, whether they sign an order entering the custody and placement as the best interest of the children, not just when you sign the document, when the court approves it. Up until that point, either of you can withdraw from that agreement, technically. So you can withdraw your consent to the agreement. So even though you shook hands, it doesn't end there. You have to have a document that you both agree to. If you don't have a document that you both agree to, you don't have an agreement on custody and placement. You can't say, this is what we agreed to, and court, you need to approve it because she already agreed to it. Because the court's going to say, well, no, she didn't, because she didn't sign this. So if you two don't have an agreement, then I guess you're litigating it.
And just to be clear, in my situation, and hopefully this helps others, what's going to be presented to the court is that we did have an agreement. And then I'm consistently backing away from an agreement, when in fact, her attorney is putting things into the supposed agreement that were never agreed to.
Well, that's actually inappropriate because settlement negotiations should not be presented to the court.
And so how do I fight that, and how do I
Your attorney should be objecting anytime they're referencing what you've already agreed to, your attorney should be objecting. Kind of ties into the whole, put it in a different example, when people would get in a car accident or a civil, like a lawsuit situation, the person would say, well, I'll just offer you money, I'll just pay you off, because I know I'm going to have to hire an attorney, it's going to cost me more, even though I don't think I'm guilty, sure, I'll pay your $500 car repair. And that they were admitting guilt based on their settlement negotiations. And so settlement negotiations are not supposed to be presented to the court because it's unfair. Because you were offering a point of compromise, but it was probably contingent on something else. So it's just not fair. The court isn't supposed to entertain it. Which judge?
McNamara.
Make sure your attorney's objecting. If they don't object, then it doesn't matter. If they don't object, then it's all coming in. Same with any other rule of evidence. If they don't object and your judge doesn't object for you.
A couple of temporary hearings, I don't think there was enough objection. That's what I think I'm finding out right now.
I find it really fun. I don't know if anybody else. Go ahead. Go and just observe temporary order hearings in the family court commissioners. Oh my God. One of my friends is a family court commissioner in Dane County, and I sat in on one of the other hearings, and I'm just looking at her like, how do you sit through this with a straight face? And I'm like, and you people paid these people to represent you in this? It's kind of crazy. And sometimes it's strategic decision. Sometimes it's a strategic decision not to object, because the question is, well, what is it worth? And looking at your overall strategy. So that's something that you just want to make sure that you and your attorney are on the same page on that. And it all depends on the person that the commissioner that you're in front of.
Crow.
Is
So,
she your friend?
Pat Crow is my mentor. I was her first law school mentee many, many years ago. Which some people say it's better because none of my cases can be heard by her. But no, and she is, a lot of times it's hard because you think that they're out to get you, and I don't know, maybe sometimes they are. But yeah, she does appreciate when people actually object. But at the same time, an issue with commissioners too is that they're on time constraints. So sometimes if they realize that the attorneys are doing something about it, they'll just stop the attorneys talking altogether and they'll just start questioning you, which could be good, could be bad.
On the 2-year rule, I believe Bradford versus Bradford enables you to actually file for modification before the 2 years, but as long as a decision doesn't occur within the 2 years. I think that's how it worked, but mainly because I believe I tried it. However, it did annoy the crap out of the judge because I was so aggressive in trying to get the bad deal I had changed. So in one way, I believe it's possible to file before the 2-year time is up, as long as the decision's not made. However, it does all prejudice the people who make the decisions into thinking that you're just a jerk.
What would matter here then is whether or not your pleadings are going to be good enough to where your case just doesn't get thrown out right from the get-go. So if they do just kind of like a summary judgment, like even looking at all of your pleadings, if you couldn't possibly perceive that the children are a substantial risk of harm, then I think it can get thrown out. I mean, if you file it like 2 months before your 2-year truce period expires, then you're probably fine because in Potter counties you're not being heard before then. But if you're planning, oh, it's a year from now, but I'm expecting this litigation to last a year, which is not uncommon, you better make sure your pleadings are good enough that you'll survive just you have to establish a prima facie case that there's been a substantial risk of harm. You still have to allege that. If you don't allege that, then I think your case can be dismissed.
You know, and I think they'll spin it any way they want. I filed mine 1 day after the 2-year period, and then the opposite side took that and said, look at what a piece of crap he is. He waited